Hello and welcome to episode 5 in season 2 of the JAIAC's Dispute Management in a New World podcast series. 40 minutes of bi-weekly conversations with Dr. Christopher Malcolm, dispute management practitioner, international legal consultant, entrepreneurial visionary, and Secretary General of the Jamaica International Arbitration Center, JAIAC. I'm your host, Roxy Nickel, and on this episode of our Conversations with Dr. Malcolm is part 1 of a 2-part discussion on I-neutral dispute management platform possibilities, innovation, and access. Welcome, Dr. Malcolm.
Thanks, Rex.
So, it's been about a year since the launch, which I was very proud to be part of, I-neutral. So, talk to us about how I-neutral has evolved.
Since that launch, I-neutral has been building out through the Jamaica International Arbitration Center, where it was then launched, and has been since as well implemented in Asia via Malaysia through the Asian Institute of Alternative Dispute Resolution, and also in Africa, Mauritius. And there are a number of other exciting options that are being pursued for the use of I-neutral globally. And we're very, very excited about that. We have also had the value of end users having come onto the system, having used it, and having been very satisfied with how it has functioned. And while nothing is ever perfect, we can say that what we did is something that we're very proud of. We're proud of how it has been received, and we're excited about it, where it will take us into the future.
Okay, well, let's go back to what was the influence of having you start the development of this platform?
The influence was twofold, really. Firstly, is that we've always thought that as you expand dispute management rather than dispute resolution options, it should always be something where you try as much as is possible to democratize the process, which is to make it easy for access, easy for reach, and user-friendly. So that was an underlying basis for having got there in the first instance. The second thing, of course, is that at the time we were hastened into getting it started. So while we always had the vision of getting there, when COVID-19 came around and started having significant global impact, including in our own region, the Caribbean, we recognized that there was an immediate need for us to hasten our steps into getting a platform available that was capable of being accessed in a way which was possible for all, online, and also capable of being used in a hybrid way as well. So if I were to point to a specific event that caused us to get to the point of establishment when we did, I would say it was COVID-19. Dispute management, as you know, relies on multiple, or as I would like to say, relies on multiple dispute resolution options. So in a regular dispute resolution environment, you're going to have multiple options, including arbitration, mediation, conciliation. You're going to have facilitated contract renegotiation, and a host of other mechanisms that could be called. So that is where you are for dispute resolution. Now, whether you're online or physical, persons want to have access to being able to have their disputes resolved in a manner which is cost-effective and which also allows them the levels of flexibility they need. Not just flexibility in terms of individual processes, but flexibility in terms of the availability of multiple processes from which they can choose, or sometimes which they may be able to mix and match. So what I-neutral does is that it has taken these very same mechanisms or resolution options and taken them for use into an online space.
Right.
So it is no different really in terms of modalities than you would find in a physical space. The critical difference, of course, being that in this online space that we have created a significant end-to-end mechanism, which allows for management, it allows for resolution, and it allows for reporting.
So how significant really is it using this online platform?
The significance really is going to depend on the parties and their respective needs. And in an environment such as what we've had with COVID, where it had become very difficult for persons to access physical locations, at least for a time anyway, physical locations and user-friendliness of physical locations. And even now, while persons are getting out of that, persons are finding that the hassle of travel and all the things related to that sometimes means that if you're able to stay home, or as we say in Jamaica, tan your yard, you're sometimes better off than simply going all over the place and doing things. So the convenience is a critical factor. And also the fact that you're able to manage your time better, and also you're able to do what you always will do, in that you have rules that you're comfortable with. You have mechanisms that you're sufficiently comfortable with as well. And you have access as well to the same neutrals that you otherwise would have had access to in a physical space.
Are you able to speak to how the engagement has been, especially now since the pandemic?
The engagement, as with anything else, it grows over time. And we've been seeing growth in it. And for me, as I said, what is important is the responses that you get from persons who have engaged with either having themselves been involved in a process involving iNeutral, or having been involved in demonstrations or other activities and seen the user-friendliness of it. And what we're seeing as well, which is critical, is that we are seeing more and more persons who, having not yet used it, who are now incorporating it into their contractual arrangements.
Okay.
The COVID-19 pandemic has ravaged all our communities. However, adversity and necessity are the parents of invention and innovation. There cannot be a more apt time to launch this iNeutral platform. The reason being is that the iNeutral platform is a unique technological innovation in online dispute management. It is ambitious that it aims to assist the resolution of domestic or international disputes between parties around the world. With this initiative, the Jamaica International Arbitration Center is rising above adversity, as this iNeutral platform application has the capacity to deal with both domestic and international disputes in accordance to various ADR procedural rules. Now, the real secret is that it is flexible to allow collaboration with other centers and institutes to use this same platform under their own ADR procedural rules. This is the long-term implication of this platform. With focused collaboration and marketing, iNeutral platform will become an important tool in resolving disputes between parties in a timely and cost-effective manner all around the world.
And iNeutral is simply a pioneer, and it will not be the last, a pioneer in innovation in the emergence of online dispute resolution. For those involved in business and commerce, especially for micro, small, and medium enterprises, and for those involved in international trade, iNeutral and other forms of ODR yet to come will do several things. Firstly, democratize the delivery of dispute resolution, reduce the cost of dispute resolution, lend even greater efficiency to the processes associated with the resolution of conflict, make more convenient access to dispute resolution, and hopefully fuel legislative reform as the law, as it always has, seeks to catch up with technological progress.
Okay. Well, we haven't actually spoken about how persons can actually access it. So can you tell us how they
Well,
can
the
do
access
that?
is simple. Wherever you are, and depending on what it is, because iNeutral is a platform which, as we say, is being used in through different institutions at the moment. So if, for example, you were to try to access it through the Jamaica International Arbitration Center, you could do one of two things. You could go to the general JAIAC.org website, and you'd be able to get access to the platform and be able to use it there. Or you could, for short, simply go to iNeutral, spelled out, INEUTRAL.JAIAC.org, and that would take you directly to the platform. Once you get there, that's where the excitement begins. Because you get an opportunity to then register your disputes online by simply going through a fillable form. And the form is fillable depending on the nature of the modality that you're using. So it's a form created that allows you to complete it for arbitration, mediation, conciliation, or whatever the modality you have to use. And every other step of the process, right through to completion, is available to be used by reference to templates that are created and are automatically generated via the system. Everything that you need to do, payment of registration fees, you have access to calendars, you have access to following your matters in terms of where they are. And if you have multiple matters registered in the system, you're also able to follow each of them as they happen. You have access to a unique library for each matter, and all of these things and all these features are available via the platform. And as I said, going back to access it, simply go to iNeutral, spelled out, INEUTRAL.JAIAC.org, and you will have easy access to a system which we, as we say, and we're proud of, doesn't require a rocket scientist or any such person to use it. It is easy to use and it is readily accessible.
So we're talking about the accessibility of it. Can you break down the strengths and benefits of using the iNeutral platform? Maybe give us one or two of these.
Well, the most important strength, I think, getting back to easy to use and access, is the fact that you can access it from wherever you are, your bedroom, your living room, wherever you are. You can access it and use it from there. So that's good. You also have the possibility there, of course, that while you're in an online space, even though your matter may be cross-border, meaning involving different jurisdictions, you can stay at home and you can use it. You don't have to travel. You don't have to undertake expensive hotel and travel arrangements and so on. You just don't have to. So that's a significant and critical strength that we see. The other strength, of course, is that we have taken very good steps to ensure the robustness of the system that has been created. The back-end IT support for it is excellent. The back-end coding of it is excellent. And again, we are saying that we have relied upon the best professionals we could have had access to create something that is as good as anything you're going to find in terms of the robustness of what it is and the fact that it actually works.
And it's beneficial.
And it is beneficial, and it is cost-effective and otherwise efficient as well.
As an independent arbitrator, always traveling with laptop in hand, I became an early adopter of cloud-based document storage and video conferencing. But if we could travel back in time just 2 short years, 2019 me would have considered the idea of online dispute resolution a Silicon Valley fantasy. Law is a conservative profession. It's based on precedent, after all, and lawyers tend to resist change. So 2019 me would have said, sure, the technology is there, but there's probably not much appetite for online dispute resolution. Then came COVID-19 to turn our normal way of doing things upside down. Suddenly, everybody was using Zoom, Microsoft Teams, or WebEx. Many of us couldn't travel at all, and even if we could travel, nobody wanted to spend hours in a conference room with strangers just for an arbitration hearing in a time when we weren't even allowed to visit our own grandparents. So COVID-19, awful as it was, wound up turbocharging interest in online dispute resolution and causing even the most stubborn technophobes to drop their resistance to using new technologies. One court administrator told me the pandemic allowed him to implement plans in 3 months that otherwise would have taken 10 years. And that's why I think the Jamaica International Arbitration Center's iNeutral initiative is such a fantastic idea. iNeutral allows every step of an arbitration to take place online, from filing the RFA to issuing the award. Now, it's important to understand what iNeutral is and what it isn't. iNeutral doesn't replace human arbitrators with algorithms. Instead, it's a web-based platform that empowers parties, especially small businesses. A simple, user-friendly interface allows parties to file documents and pay fees online, to select arbitrators from the list of neutrals maintained by JAIAC, and to have hearings conducted via any of the popular video conferencing platforms. Multi-channel audio features in video conferencing software make it easy to add real-time simultaneous interpreting, and in fact, iNeutral currently offers translation support for English and Spanish as an optional add-on. A cloud-based document management system means that all participants in the case have access to the documents they need, when they need them, from wherever they happen to be at the time. That, in turn, means that arbitrators, parties, and witnesses can be anywhere in the world, thus eliminating airfare and hotel expenses and the need for visas, while reducing travel time, jet lag, and other disruptions to busy schedules. The simplicity and flexibility of iNeutral can encourage businesses to choose Jamaica as a neutral seat of arbitration. At the same time, it can enhance access to justice, especially for the owners of microbusinesses and SMEs who will have a mechanism for resolving disputes from their own homes or workplaces.
Let me remind you, those of you listening and watching, that you are tuned in to the JAIAC's Dispute Management in the New World podcast, Conversations with Dr. Christopher Malcolm, Secretary General of the JAIAC, the first of a two-part discussion on iNeutral dispute management platform possibilities, innovation, and access. So, Dr. Malcolm, what are the requirements to use the iNeutral platform?
The first requirement for using any form of alternative dispute resolution is that you must have an agreement between the parties to use ADR. Mm-hmm. And where you're seeking then to use iNeutral or any other special platform, the parties must also agree to its use. And the reason, and just to contextualize that a little better, and just for those persons who may not be fully aware of it, where you try to go to court in what we call litigation, you have a constitutional right of access to the court in the relevant jurisdiction involved, right? So you don't have to get the permission or agreement of anyone to be able to sue them.
Right.
However, where ADR is concerned, and when I say ADR, I'm speaking about arbitration, mediation, conciliation, neutral evaluation, and a range of other options that could be relied upon. You need what we call a contractual right of access, meaning the parties must specifically agree in a manner which is enforceable in court if necessary to using that mechanism. Right? So that is what must first be done. So for you to be able to use iNeutral then, in short, you must first be able to demonstrate that the parties involved, yourself as a requesting party, let's say, mm-hmm. and the other party who is expected to be the respondent, you need to be able to demonstrate that both of you, and I'm using two parties for the minute instead of making it complicated with multiple ones. You must demonstrate that both of you have agreed that you wish to use the iNeutral platform to resolve your dispute. Right. Once you have demonstrated that, you then have access to, and you're able to then go to the platform and do what I've indicated. You go there and you simply get onto the site, make a formal request for arbitration, mediation, whatever it is, and you will have a fillable form made available to you, which is easy to use. So you simply go in, click some buttons here and there, and then you will be able to add in some wording here and there and be able to upload documents and so on to then be able to complete your request. And once you make that request completed, it then will be directed to us, to the Secretariat of the Jamaica International Arbitration Center, and also copied to the respondent, who will in turn have the opportunity to respond using a fillable template as well.
Right.
And the process will continue on to involve your neutral, your arbitrator, your mediator, or whoever else is involved in it as a neutral. They too have access to fillable forms for their procedural orders and for the other things that they're doing. So the system is designed from end to end to be user-friendly and to make it easy for access for everybody wherever you are. And you don't need to be specially trained to be able to use it because it was designed with everybody in mind.
So definitely user-friendly will make it easier.
It does,
to go through the
yes.
process. All right, Dr. Michael, can you explain the process management used by the platform?
Well, the process management system that has been used has been specially designed or coded by our IT practitioners. And what it in substance does is that it allows for everything that is done from the point of entering the system and registering to the very end where a decision, an award, whatever it is made. All of that has a designed process flow which, with different parties having access to different components of it as required for them to be able to do what they have to do. And in that process management system, you also have a unique identifier given to each party. So once you get into the system, you log in, you get your unique passwords, you get your unique access, you get access to some things which are considered public, for example, which is a public library. And when I say public, I mean public to the parties involved.
Right.
A library of documents that are available to both parties, but you also have access to your individual component parts, where you can communicate with your lawyer, communicate with whoever it is, and not have others have access to that. So the process is designed to be compartmentalized as is appropriate to maintain the privacy between parties and their lawyers and other advisors. And also generalized to ensure that to the extent that there are common elements of it that must be shared for the seamless functioning of the system, that generalization is also possible.
Okay, thank you. So the process of procedural rules is it compatible to in-person's dispute management procedures?
Exactly, it is. And I'll tell you in what way. Once you get into iNeutral, whichever dispute management institution is making use of the system, what you will then do is once you come in it, iNeutral does not have unique rules per se. What it will have is access to the rules of that institution relating to arbitration, relating to mediation, relating to facilitated contract negotiation or whatever. So those rules that you have access to are the same ones in terms of process flow that would be available in a physical matter.
Okay.
All that has happened is that we have taken it on for convenience and for the interest of the times that we're in, into an online space where you may go. And in fact, the system is so designed that you may even be able to use the process management component of it and still find yourself being able to, for example, have a physical hearing, which would then end up in a hybrid arrangement rather than a purely online arrangement in a particular case.
Okay, thank you. So just for emphasis, once again, the entire process can be done online, right? Which means that it's not just the request for dispute resolution support that takes place online, but actually the literal arbitration, as you said, it may happen, or other mediation or other process. All of this can also be done virtually, correct?
All of it can be done online.
All of it.
Every single element of it. End to end of a dispute resolution process in mediation, in arbitration, in conciliation, whatever it is that is made available, can be done online, and you do not have to meet face-to-face with anybody.
Which is inclusive of hearings.
Which is inclusive of the hearing, and inclusive of the publication of the award or decision that is made after the hearing.
Thank you. So we've gotten that straight. So in terms of updates, now, are persons provided with reasonable updates on the status of their iNeutral matters?
Always. And in fact, what is more, once you tap into and you're using the system, you have access to your own calendar and your own status update, which you can, at the click of a button at any time of the day or night, click onto to follow your matter and to see where it is at. You can determine where the delays, if any, are in the system. And similarly, that the Secretariat itself will also have access in each case to look at the status of particular matters to see where they're moving and to see if there are any glitches in the system in terms of process flow that need to be called into action.
Are there any other offers that we've probably missed from the iNeutral platform?
iNeutral is not intending to change the procedural phase per se of how an arbitration or mediation happens, save and except that instead of being in a physical space, you're in a virtual space. But everything that you would ordinarily have happening, a request, an acknowledgement or a response to that, procedural orders being made by a tribunal, a hearing being convened, and a decision being made. And there are several steps between that happen as well. All of those things happen there as they would in an ordinary physical arbitration. And in fact, every time a decision or something is made, you will then have automatic things sent to you. And so there is a complete sharing of information at all stages, full accountability and transparency in the system.
Awesome. So let's now talk about two mechanisms on the platform that we haven't really discussed much: restorative justice and facilitated contract renegotiation. Can you tell me what?
I'll probably start with the latter first.
Facilitated contract renegotiation.
All right, let us start. What happens in a regular commercial setting? Commercial arrangements are bound by contracts, right? Meaning you will have in order to secure the performance, you will have what we call a contract being entered. And what is a contract? A contract really is a tool of commerce which establishes and provides for the performance obligations of the respective parties. So the contract will set out what party A must do and what party B must do. And in the event that party A or party B fails to do what he or she or it, as in the case of a company, is required to do, then you can have a cause of action for breach of contract. So that's the starting point. Now, because the contract then becomes the regulating tool of the transaction, you will at all times be concerned as parties to determine whether the other party is doing what he, she, or it has agreed to do. And if they fail to do that, then they are in breach and consequences could flow. There are instances where that may happen, and then what you realize is that sometimes the breach that happens, or the breach that appears to be about to happen, may be something which is entirely without the control of the parties, or things where even if it is within their control, you recognize that the maintenance of a relationship is something which means that the parties should talk to each other and try to change the terms of the arrangements, because it may have become difficult to implement for one reason or another. Say, for example, the price of oil may have gone down, and let's say you negotiated a contract which said that oil would be sold at $20 per barrel, and it became uneconomic, and the parties decide that, let us see if we can renegotiate the terms so the price of oil gets down to 15. And I know that figure is fanciful at the moment, right? Oil is nowhere near 15 or $20 at the moment. But I just use that by way of an easy example. The parties may say, something? Instead of considering this to be an actionable breach and taking all the steps, we've built up a relationship over 20 years, we've done all these things. Why don't we just seek to see how we can meet, assisted if necessary, and that is where the facilitated comes in, by a third party who can help us to renegotiate the terms of our agreement. So we can change existing terms to then implement new terms that will make it easier or more feasible for the contract to be performed. So what happens in the case of that now being a dispute management process is that you have an arrangement where the contract is no longer capable of being performed as was intended, or is on the verge of becoming incapable of performance in that way. So what you then do is that you engage an independent third party who is able to help the parties to negotiate with each other, a renegotiation process, who will then take their own skill sets and so on to assist this process. And at the end of that process of engagement, The idea is that you will come out with a redrafted contract, with a new contract in substance, right? That then, let's say, delivery was for 30 days and you say, okay, fine, I'll change it to 45. So you're not coming back with new terms. So what that does is that it prevents the dispute from happening in some instances, or where a dispute may have already arisen even. It now allows the parties to, in an amicable way, and by reference to adjustments to their contract, bring performance back into focus in a way where the parties can be comfortable. And that is what this process is all about. The other one you asked about was restorative justice. And that one is something which typically is a back-end mechanism and typically used in criminal law settings. And what happens? Where there is a crime committed, there's a perpetrator of the crime and there's a victim of the crime typically. But if you think about it, and if you think about how crime is treated in our societies, a crime is treated as a public law matter, as distinct from, for example, a contract which is treated as a private law matter. Why? Because where a crime is committed, it's thought that even though you may have a direct victim and a direct perpetrator, the effects of the crime affects us all as a society. So if somebody, for example, murders somebody, right? All of us in the society feel insecure as a result. Because we're now seeing things happening around us which have direct or indirect impact on us. So that is a matter which the government will take a direct involvement in trying to ensure that there's peace, security, and that people feel a sense that they can in fact be assured by the processes. But when the crime happens, if you're not careful, you could end up creating a vicious cycle. So let's say you have family A and family B, right? And let's say one member of family A murders or rapes, let's use rape, rapes a member of family B, right? Then you now have a situation where there's angst between both families, because what is happening is that the persons from the family who got raped now have a situation where they feel a sense of betrayal. They feel a sense that they need to get their own due. But when you go to court, a decision is made by the court in the interest of punishing the offender, but is very often not victim-centric. So what restorative justice tends to do is to say, look, whatever happens, we live in a single community. And what we need to do is to ensure that when these disputes are resolved and dealt with, we try to, as much as is possible, ensure that there's healing in the community, or that there's healing made possible in the community. So what restorative justice does then is to try to bring the parties together so there can be a reasoning or an understanding between victim and perpetrator. And when you talk about the circle that you're now creating, it's not just a direct victim and direct perpetrator. It's now the families related, because what you want to do is to cauterize the problem, so that you don't have members of the raped victim B, where the person raped came from, feeling that they must then take revenge and they must act in a vengeful manner towards any member of family A and so on. So what you want to do is to create this holistic arrangement where people can talk and hopefully move to a point of understanding, so that you can prevent a cycle being perpetrated and going forward. So restorative justice then allows a mechanism for this sort of dialogue to happen, and you then get a trained person who will intervene as a third party to assist the dialogue. And this process can be painful and it can be time consuming, because very often you have to engage with the respective parties individually. You will get, for example, in the case, let's say, of the rapist who is in jail, you will try to get a position where he then is able to meet face to face with his victim and with the others to try to express his sorrow for what has happened and to try to come to terms with it. And the victim in turn will have questions like, why me? Why did this happen? Why have all the persons in the world you chose to offend me? And try to get to that point now where you can get to a position where at the end of it, people will not always come away being completely happy, but at least they will come to a position where they're able to come to terms with and try to have a better understanding of what happened. And what that hopefully does is that it enables people to move forward, not forgetting what happened, because you never will, but at least getting to a point of saying, you know something, we can move forward knowing we have come to terms with it. And if I mentioned murder earlier, and think about murder. Very often, for example, if somebody is murdered, and especially in circumstances where the body cannot be found.
Right.
Until that body is found, you know. The members of the family are at pains trying to figure out, they can't bring closure. They can't bury a body. They can't do anything. So what you want is to have an arrangement, and restorative justice can do that as well, where persons can then bring closure to the families and people can move on in a state where they're a little more at peace than they otherwise would have been.
So iNeutral has brought dispute management right to our fingertips.
It has.
Wherever you are in the world.
Wherever you may be.
So how do persons contact the JAIAC and with any additional questions that they may have on the services offered?
First thing you may want to do is to go to the website, which is jaiac.org. And there's an easy number to call as well, from anywhere in the world as well, 876-416-5390. And you may email to info@jaiac.org, and by doing any of those things you can in fact get access to the JAIAC, and you're able, and in fact if you go to the website there, you can in fact you can send in questions and so on direct from the website, so there are easy to access features on the JAIAC website that will be available to persons from wherever they are.
Before we go, here are today's Did You Know facts. Did you know that the JAIAC provides for fast-track arbitration? Did you know as well, hearings and the secondary costs, including for hotel, food and beverage, and transportation in Jamaica, is more competitive than in any other Caribbean country? Please remember to check out all of our podcast series Season 2 episodes, now available on Buzzsprout, Podbean, Spreaker, the JAIAC's YouTube channel, and wherever you get your favorite podcast. Until then, I'm Roxy Nickel. On behalf of Dr. Christopher Malcolm, Secretary General of the JAIAC, saying thank you for joining us. Special thanks to our sponsors, JDIC, protecting deposits for you and me, CIADR, Regis, work your way, iNeutral, dispute resolution made easy, CP Malcolm, dispute management practitioner, ADEB Consultants, consulting engineers for almost 60 years, Impact Justice, improved access to justice in the Caribbean, and Wassel & Wassel Arbitrators Services Incorporated.
I save because one day my little business is going to be a big deal.
Yeah, and I make sure to put away a little something for him.
And thanks to JDIC, deposit insurance protection on my savings gone up.
You've been upgraded. Deposits held in commercial banks, building societies, and merchant banks are covered under the JDIC deposit insurance scheme up to $1.2 million per depositor per institution. JDIC.
Protecting deposits for you and me.
Book rooms by the hour or as long as you need. Regis meeting rooms are the perfect setting for your next pitch, interview, board meeting, or workshop. They're equipped with the latest technology, a friendly support team, and catering on request to ensure everything runs smoothly. Experience our meeting room solutions. Book your tour today by calling 876-618-8800 or visit regis.com.jm. That's regus.com.jm.
All our episodes are also distributed on Google Podcasts, Spotify, Apple Podcasts, Amazon Music, Deezer, Stitcher, Podcast Index, Pandora, TuneIn Plus Alexa, Podchaser, Podcast Addict, and wherever else you get your favorite podcasts.